I propose we start our first panel after lunch. For those who just joined us, I'm Elena Rey. I'm partner at Brown Rudnick Litigation Funding Team, and I'll let my panelists introduce themselves.
So, Josh Katz with Gramercy Funds Management.
Chaya from Gateley Legal.
I'm Hugo from SITS Capital.
And I'm Chris Benson, Managing Partner of Leigh.
Excellent, thank you. So law firm funding is one of my favorite topics. We're definitely seeing this as a big trend in the market. There were obviously a number of very large deals and investments in this space this year, and we've been working with many of you on other investments and due diligencing of law firms, as well as working with law firms looking for more sources of capital. So I think it's a really interesting panel. We have here both funders and law firms representatives. So to start, Joshua, maybe first question to you.
Yeah.
Obviously, one of the big, most significant deals in the European market in the law firm funding space. So maybe if you can walk us through how you were selecting your investment, why law firm as opposed to maybe a number of portfolios, how you would due diligence your counterparties, and how you approached investing in the European market in general.
Yeah, a lot there. Let's see if we can unpack it maybe piece by piece.
Very excited.
Yeah, I have very little to say on this topic. So, all kidding aside, I mean, whenever we look at an investment, now I'm going to steal Hugo's line here, we look at zip code risk or area code risk, right? Which is, what is there that's unique to this market that we need to know kind of ahead of time? And it was funny because after we closed the deal with PG, I looked back at my first emails, and my first email was to our transactional lawyer asking if this PACCAR case could in any way impact us. The answer is thankfully no. But it just goes to show you that when we initially underwrite a transaction, we really are focused on that local market. What is there in that market that we need to understand that's going to really impact the structure of the deal, the underwriting, and that's a great example of something where we want to get really local about a risk. So when we start, that's where we start. What's the zip code risk? And then moving to, PG is a good case study of this. It's what does the firm have? I don't think this is a state secret. We start with the collateral, right? If there's not a good case, I'm not sure there's much to do. If there's a good case, then you can move on in your underwriting. We're pretty meticulous. I see some PG people here. They're probably putting their heads down now. We really do look under the hood quite extensively regarding the collateral. Because to us, when we take a step back, the biggest risk, assuming you really like the collateral, is the operator. And we spend a lot of time with the senior lawyers at PG, just understanding how they view the world. And why do we do that? Because if we're going to get into a business relationship with them, we want to make sure that on the other end, litigation is dynamic. We can't predict how it's going to go, and we really want to make sure we are thinking and they are thinking like we are. So there's a shared understanding of how this will go should there be a right turn in strategy. We want to make sure there's a real alignment of thought, because to me it's a real partnership, and what we're investing in is the operator. Good collateral, good operator, and so we focus on that piece, right? How do you think about the case? How do you think about strategy? And for us here, we really looked under the hood. We loved the collateral. We got really comfortable with the senior lawyers, their strategy, how they think about the case. We talked to people in the market. I lost count, but I think on that transaction we had probably over 20 different diligence providers, often specialists looking at certain aspects of a trade. And you're taking the information and you're holistically looking at the opportunity. And I'm trying to just nibble at each of these. I could talk through the whole panel on each one of these, but I'm trying to just give you a little piece here of each of these. And with respect to structure, again, going back to my initial comment of operator, since that to us is kind of the biggest risk once you get comfortable with the collateral. Once you look at the operator and you get comfortable, to us it's a question of, do we want to do something or do we kind of want to do everything? And when you look at a firm, there's always this tension if you're not kind of taking all of the sleeves of where do their best lawyers go? Like what cases are they going to be working on? And we try to avoid that. We don't want oh, this other case started getting really interesting, and then you have good lawyers moving to that case. Maybe that's not in your collateral pool. So good operator, and we take that risk off the table, that kind of divided loyalty and the staffing. And it allows us to work with them on budget in a more granular way, because everything is kind of within the collateral pool. So that's how we look at it. You know, we do single case, we do one portfolio of many, we do entire firms. It just, you have to line up the operator with kind of what you're looking at and their collateral.
Thank you. I think it's a very interesting example of, the benefit of funding one law firm as opposed to maybe portfolio of cases, which is another very popular option. Hugo, what about you? How do you select your investments?
The law firm lending space is really so different than the litigation finance space when it comes to selecting investments. From a jurisdiction perspective, for example, the UK is super competitive in the single case funding space. I mean, everybody sitting here today definitely looks at that market, provides capital to that market. So for us, being located in Switzerland, we'd have to compete on price to really make a difference, and that's not what we like to do, so we tend to co-invest in this market, whereas in law firm lending, instead of competing on price, we can compete on terms like credit providers do, and that could be covenants, it could be sort of liquidity being released in time, it could be providing a proper loan versus an asset-backed kind of cash sweep facility. So we like to compete in the UK market, for example, on non-pricing aspects, which is why we like that market. So we look for these deals where it's not a race down to the lowest interest rate, and we can provide something that's very custom, very flexible. So I think that's really how we select the deals in law firms. In law firm lending, it needs to start there. The second thing is, again, back to the operator point. I mean, I kept shaking my head because that's just so important. And for us, there's a threshold where you can start using law firm lending as a firm. So obviously, you need to meet our cost of capital, you need to be a success fee driven business, because otherwise, an hourly business would command banking type cost of capital. So we look for these businesses that need some support on their balance sheet, but that are at a point where they're solid enough that they can support recourse lending. So I'd say it's sort of a next step to litigation finance and portfolio funding. Law firm lending is kind of the evolution. So we look for these law firms that are institutional enough to be able to support not only the leverage, but also the reporting, because we don't provide cov-lite facilities. We're full of covenants. They're very adapted. They're financial covenants, but also very law firm covenants that we've never used in any other credit facilities. So you need a firm that can sort of roll up all the information and sort of structure it in a way that we can get compliance certificates done, signed, approved. We can follow the inventory. We can follow basically every metric that you need to anticipate a credit event in a law firm. So we are lending first and foremost to good businesses. And I think that's the key. You need to approach it from the business side before the litigation finance side. The litigation finance side, so the actual collateral, what we think of as collateral, is great because we understand it, and we think of it as assets. So we definitely think about LTV against fee receivables, but first and foremost, it's all about the governance and the business. So this is where we start, or at least this is not where we start today. We started from the asset before in our first deals, and we realized it's the other way around. So it's corporate credit before being asset-backed financing.
Yeah, it's very interesting. So you mentioned a few elements like financial covenants, heavy information covenants, and this is a lot we're seeing on law firm funding facilities, and probably less on sort of portfolio or case funding that can be even unsecured in certain cases, which always scares me as a leverage lawyer by background. But how do you? So obviously, really good arguments about why law firm funding. And just to look at the other side, obviously insolvency is one of the main risks for law firm funding, as opposed to funding portfolio of cases of several law firms. So how do you approach this risk and mitigate it?
Yeah, I mean, the insolvency topic and the enforcement topic is always a tricky one when we do law firm lending. Obviously, we started law firm lending in the US with certain people who are in a room today, and we then moved on to in parallel, the UK, Spain, other jurisdictions where obviously the logic is completely different. I mean, transferability of cases is very different from jurisdiction to another jurisdiction. So if you find yourself having to enforce on what we call collateral within the docs, which are essentially the cases, the inventory of a law firm. There's so many things you need to think of. First of all, are you allowed to do it? Who actually handles the transfer? Can you get cash consideration for a transfer? You need to enter into co-counsel agreement, referral agreements, and then you need to think about data protection laws, consumer protection laws, getting approval from the SRA here, but other bars and regulators elsewhere. There's just so many layers of complexity when you think about what happens when a law firm goes down, what happens to the assets of the law firms, that's its people and its cases, right? And how do they operate in a situation like this? We find that we look at the duties of lawyers very closely because when they can no longer service a client in a case, they also have certain duties under their statuses, so that could be helpful in how we structure certain covenants, reps and warranties in the docs. So this is interesting. But also the flow of funds. For example, Spain, which is a jurisdiction we've been looking at very closely recently in law firm lending. The money flows from the defendant to a court agent before it actually hits the accounts of the law firm, the client account of the law firm. So if the law firm goes bankrupt, what kind of recourse do you have on that court operator? Because they're independent. So where does your cash go at this point in time? How do you keep track of that? Can you set up escrows? Can cash flow to your escrow before the law firm? And again, Spain, completely different. So we have people like you, banking and finance backgrounds, credit backgrounds on the legal side, and litigators and very often restructuring lawyers also helping us there.
Yeah.
I was going to say, everything you just said, Hugo, we see eye to eye on, not surprising. But I think that Hugo, you hit on this, as you really highlighted, which is we start on day one, which is we're trying to avoid an insolvency, so we're really focused on budget compliance from day one, right? Having a realistic runway, right, with some buffer. Because it's litigation. I mean, I think everyone in this room knows it never goes exactly to plan. And often when it doesn't, it runs long. So from day one, we're trying to make sure that the law firm understands what runway it has left and how it could increase that runway should it need to. Hope is you never need to increase the runway, but you can't look at it only in the, using a baseball analogy, only in the ninth inning. You got to start thinking about it at the first pitch.
Hey, the budget aspect. When you start diligence and you ask a law firm for its 3-year business plan, I mean, probably 10% of the time we get one. I mean, obviously firms like Leigh or Gateley, that's what I call institutional shops. So these guys, they have professional corporate management. It's not just a couple litigators running a boutique, but very often even mid-sized shops, the concept of a budget, it's always backward looking. So here's our sort of cash accounting, but thinking about WIP accruals in the next 2-3 years and sort of change of case mix, how that's going to affect success rates and what I book on my accounts. I mean, all these conversations, you can't even have them sometimes. So it stops the conversation short, but the budget aspect.
But does that impact what type of arrangement you would do with the firm? Right, if they don't have kind of what you think of as institutional budgeting, would that lead you to maybe more of a portfolio loan with them versus a law firm loan? Would that just take them out of consideration total? I'm just curious. I know everyone views it differently, and we do think about it in that way, which is if the institutional controls aren't to the level, maybe that's not someone we want to do a law firm loan with. Maybe we want to start with a smaller facility with them and kind of grow with them.
Definitely, but I think when we see that in the U.S., the accounting for law firms is very different because you don't have the adverse costs concept in the U.S. It's hard to book and recognize revenue from worked hours. So the accounting of law firms in the U.S., if you've done credit in the past and you look at the negative equity position of these law firms that borrow, you're shocked. And then so in that market, that's why I think also it's way more of a cash sweep, asset-based type of approach, where you're providing runway for costs through your facility, and then you just anchor your facility on a portfolio as the case is monetized. You take cash off the table. Whereas in the UK, what we found interesting in this market is because you do have WIP accounting, because you do have actual income while success fees aren't hitting the cash account, you can have real interest-bearing loans with proper ICR, your debt service covenants and whatnot that you can't have in the US. But when we don't have that in the UK, for sure we're going to look to carve out as a non-recourse trade. Unfortunately, at my firm, we don't have like a non-recourse portfolio mandate. We have single case and law firm lending. So we're usually not the right person there, at least today. But certainly that's an option. That's absolutely an option. Yeah.
So a lot of due diligence, and I think yes, time spent on understanding how the case management works and the law firm management works, and that's what we're seeing as well. So whenever we are requested to work on a due diligence and the deadline is a week and a half, it always makes me much less comfortable than if the client, the funder, spends proper time to look at all those important points that you mentioned. That is usually takes a few weeks or months, but then the outcome, those deals actually close much more often in our experience than those that sort of are rushed towards tighter deadline and then maybe fall through. So Chris, Chaya, I guess on the flip side, it would be interesting to hear from the position of a law firm, what are you looking for when you're raising, when you're looking for your funding partner? Are you looking for a key provider for credit line for the whole law firm, or different funders, working with different funders for specific cases and portfolios? What's sort of your approach? Chris?
I'm happy to go first. So I think it's hard to come across a lawyer who says we enjoy the process of getting funding case by case, because it's one of the most tedious things. So the attraction of having portfolio funding or law firm funding is that it takes away that pain. Having said that, I wonder how much that happens in practice, and it'd be interesting to hear from Josh and Hugo to what extent. I mean, Hugo, you mentioned you don't do portfolio funding, so your funding is completely different. But to what extent do you look at each case, that at least in the collective actions area, as opposed to saying, well, I've funded this firm and this practice, so I trust the lawyers to make a decision on this. Can we avoid an investment committee, or do we get back to the same position of, well, it's just a shorter period because we know the people and we know the team, and then you've also mentioned all the reporting requirements. So could it be that we're just replacing one headache with another? I think that's something it'd be interesting to know how that works in practice.
I can go first. I laughed at the analogy of replacing one headache with another, but it might actually be the most accurate way to look at this, unfortunately. Where I look at it is, once you have comfort with an operator, you don't have to do that part of the diligence again, but at least for Gramercy, whenever we're looking at another asset, even if we're with the same law firm, we're still going to diligence that asset. For our investors, as good steward of capital, we're never just going to take someone's word for this is a good asset. However, once you've built up that rapport and you're getting the internal memos and you have real faith and confidence that those internal memos are right, it does make the process shorter. You also have built a rapport where you can just ask the very blunt and questions and you're not dancing around it. So I do think it makes the diligence on additional cases quicker, but in our view, it doesn't take away that you're going to do it. We're still going to do it. It's just going to be easier and more efficient.
I think I think the other issue is when the funder that you're working with doesn't want to fund a case, and then you have to go to the market to try and get funding for that case. Then there's the inevitable question of why is your funder not funding this? Why should we spend our time looking at that? Sorry, Chris.
So how do you answer that question?
Well, I don't have that problem because we don't have a facility and we're not funded. That there is a facility in place at Gateley, but it's mostly for insolvency cases. So, if I had a choice, I would keep it that way, because we don't want to have to deal with this issue of, well, we can't do a case just because other funders would not be interested.
I think firm funding is probably the end game. You start with your individual cases. We've got about 80 group claims at Leigh, half funded, half not. Some of them are interrelated. And in the end, I think it is your headache point. If you've got firm funding, you've got one funder. There is, in terms of cost, is obviously important, the interest rate of the funder you want to go with. but it is, I think, how you deal with the first of right refusal for future cases. So obviously if you're going to fund some of them yourself, not too much of a risk. But I think it's also getting the lawyers to think like economists a little bit in terms of looking at the WIP and the budget and the runoff and how it's going to be dealt with. And I think trying to separate out the lawyers doing the law from the actual running of the business, because lots of lawyers just want to do the cases, so you've got to facilitate them to get the structures above that, because lots of lawyers at Leigh have got no interest in the finance, they've got an interest in access to justice. And the management of the firm gives them the ability to do that through the work we do with the funders, just to let them get on with the job. But that, you know, there's a report out today, the April report, that cases are taking up to 60% longer. Trying to budget for cases, lots of the Leigh funded cases, taking a lot longer. I'm looking at some of the funders that are funding our cases, taking a lot longer than we said they'd take. COVID added 2 years, you know, delays, courts get busy. I think trying to fund the predicted life and then the actual life, the flexibility in that budget is what law firms need.
But it's funny what you mentioned, because I don't know how you guys do it at Gramercy, but when we think about law firm lending, it's a loan, right? So you get an amount. You can have accordions and sort of top-ups that are available subject to certain conditions, but you get a loan, and as long as you stay within the covenants, you don't need sort of approval to do this and do that. And you know, for example, if your problematic is to say, well, we need that much today, but we may need to get 2 million more for that case and that case in the future, then we know it, and we carve it out as basically an exception to the no further funding rule or no further indebtedness, and we can say that's exactly what I mean by tailoring and having flexible, and that's why there's never diligence that looks the same. So I'm like, I'm going to recycle my old memo. It never works. Just the title and the template, really. But it's always super tailored, and that's the sort of stuff where I think law firm lenders like to compete on. It's really providing the flexibility you need, or the lack of flexibility they need, and just sort of make sure you got enough headroom with your LTV, with your covenants, that they don't get triggered every 2 weeks and you need to sort of restructure or renegotiate. So that's why it does take time. I mean, saying you want to close a loan in 1 month will probably put off a lot of people. It is a corporate finance project. But for sure, once you raise and I'm really discussing law firm lending as a recourse loan, but when you raise that, you're at peace for the next, our loans were typically 4 to 6 years of the loan where we participate, or about that type of maturity.
But do you think the law firms need to think about what cases they're going to have in 6 years if they want to keep rolling that facility to top up as cases settle at the front? Do they need to be thinking about what's coming down the line, or is that not so much of an issue?
I wouldn't think so. I mean, it's not, again, it's not about the case in itself. It's about you as a company, as a business, your strategy. For example, in the US we saw there was a big mass tort, Camp Lejeune, a few years ago, and you had a lot of firms that would typically never do toxic torts and all of these types of environmental litigation that suddenly moved into that space because opportunistically they thought it was a good risk reward. So these firms, some of them were funded. I doubt they had to get a waiver from their lenders, but at the end of the day, if taking that decision puts you in a default, then it's your responsibility. I think it really, law firm lending, it has the name law firm in it, but essentially it's just lending, right? We think the way we presented it the first time, our first law firm loan was actually to a personal injury business, and so it threw off a lot of our IC, we're a family-owned Swiss group. It's not in the culture in Switzerland. We told them, stop thinking about medical malpractice, employment liability, just think about a professional services business, right? And look at the loan as if you were just underwriting a professional services business. Where would you put the EBITDA leverage? Where would you put these metrics? And these metrics, what kind of covenants would you look for? And suddenly sort of bringing it back to traditional finance helps, because I think that's what law firm lending is. That's how we pitch it to our investors. It's in a separate fund from litigation finance. We have different LPs. So it's just the logics are quite different. And we really tend to enjoy the processes of speaking to management at the law firm, because those who end up going down the road in diligence with us, they actually think about their business this way. So yeah, it's not about, what am I going to do in 5 years? you need flexibility. I mean, I don't know how involved you are in the whole, or were in the small claims sector in the UK, but with everything that went on from a regulatory perspective, lots of businesses had to, do asset sales and pivot.
Get out.
Exactly, and that needs to be also sort of things that the loan enables you to do, not put you in a default situation. So that's what law firm lending is about. It's not as commoditized as litigation finance is today, I'd say.
And when we look at it, there's law firms by nature have a core group of senior lawyers, and that's a large part of what we're investing in, right? Is those senior lawyers training the juniors, running the cases, and for us, it's bandwidth. You have 4 senior lawyers you trust emphatically to run cases, and when they start talking about new cases, for us it's, well, am I going to lose you on your biggest case so you can go develop a very small case? Those are the types of conversations we try to have, which is how are you thinking about staffing the new case? What is it going to do to the staffing on the case that makes up 75% of your collateral? And we always try to put it into business terms, which is your Apple, right? Are you going to take your best and your brightest and put them on the iPhone, or the little thing that no one buys anymore? I don't forget what it's even called anymore. But you wouldn't put it on something that makes up 2% of your market share, right? You'd be focused on the iPhone, the iPad, not the thing that you sell 5 of a year. And if you think about that with law firms, it's kind of the same thing as we think about it, which is you've got really good lawyers. How are they dedicating their time? And if you have those conversations up front, adding cases for us is not usually a problem because we're really aligned in that. We've talked about it before we close, like how are you thinking of growth? What are you looking to do? Who's in charge of it? Sometimes you have dedicated lawyers that they have time set aside for those things. So we just try to have those conversations up front. Again, you're never perfect because things come up, but we try to deal with it up front.
Just to illustrate that, one part of diligence we spend time on in the UK with law firms is how they put forward their staff for rankings, for example, because that's super important talent retention. So we speak to HR, COOs and stuff and just understand how they put forward their sort of promising juniors or mid-levels and sort of what the policy is for like taking interviews and all of that is super important because we see when things get rough. First thing you cut is lawyers, and a few lawyers leaving that have influence or that reflect well on the firm because they qualified at good schools or they have a great reputation in their market. I mean that creates an exodus, and that's what you don't want to see because you're left with cases and the lawyers. So and potentially cases following the lawyers as well. Sometimes it's harder in the UK, but in the US it happens. So this is like certain. That's where we get our private equity team involved actually in these, which I forgot to mention, but we do CDD with our PE guys on law firm loans because it's just not a legal process. So that's as important, I'd say, as sort of cases you're undertaking. And
It's interesting that you talk about, you take lawyers away from the biggest case, and because obviously you can see here why there could be tension between what a lawyer is thinking with access to justice and trying to bring a claim no matter what, the size is compared to the biggest one. And so it just illustrates the point that there could, that there is an obvious but understandable tension between the two.
And I think but rather than kind of burying your head in the sand and not acknowledging it, we try to acknowledge it up front. And, law firms are often driven by money, hopefully at least partially, but also this point of what they believe in, this access to justice. And we believe in that as well, and we want to be upfront. We want to help support that. It's good for society. It's good for the firm from a reputation, from a ranking perspective. So we're really cognizant that some cases you should pursue and maybe even staff in a way that isn't economical for the greater good, whether it's the firm, society. So we're not saying you can only work on cases that have, the highest and best value. I think there should be a place at law firms for those cases that will help put the law firm on the map, help society, help maybe even change the law in your other cases. And having those conversations up front avoids the pitfall in the back end when you see staff moving.
Yeah.
And one of the risks we discussed last time we had a chat was just about how law firm funding, litigation funding is viewed in the courts, and I think doing the cases that you wouldn't do because they may not be most profitable is a way to build acceptance, because when we first started doing funded work at Leigh, the defendants raised it, the judges asked about it, you see it in the Packard judgment, it's a question, is this undermining the claimant's access to justice? So you've got to, we as a law firm have got to be able to show that it's benefiting access to justice, and doing those cases within the portfolio of work you do is really important.
I couldn't agree more.
Law firm lending is a tool that inherently supports that, because most of law firm lending in the US is to the plaintiff bar, in the UK to success fee law firms. So you're just providing them with the balance sheet they need to actually do that work and take the duration. I mean, when you look at certain medical malpractice cases, it's like 15 years before you get judgment of liability, but the actual payment, there's a lag often, and you just need to provide the balance sheet to law firms to actually take on these cases. So I think that's, I mean, when we went out and sort of initiated our law firm lending program, we never sort of claimed to do any ESG work specifically, but it just so happens to be that if we were to get the law firm lending fund with a ESG certificate, it would be an easy diligence for the people delivering that certificate, because it is 100% of the time pushing access to justice and usually fighting some of the ESG fights. I mean, the firm you're supporting is the epitome of that, but smaller firms, less visible, are also leading that fight. I mean, in the US, environmental tort is just a huge thing. One of the latest trades that we did is in sort of a water contamination realm of litigation, and in these cases, I mean, you get some environmental cleanup, S, because money comes back to populations that are typically more rural areas, and the G, because you just hold these big corporations accountable, and so you can hit the three letters of ESG with these instruments, and even more than litigation finance, I'd say.
Thank you. My next question was about maybe disconnect between the ask of a funder and what law firm can offer, but I think we've covered it a little bit, so I wanted to twist it more and you asked the following question. You talked so much, Hugo and Joshua, about all the very valid and reasonable requirements about how the law firm, should operate, should run, how it should manage the cases, look after the staff. So it just occurred to me, how do you sort of control or manage this process post-funding? So I want to talk a little bit more about, what can we do within obviously our framework post-funding, because your investment in a way is equal to equity investment in a law firm, which is obviously not what we're doing through the credit bureau. And so how do you manage this sort of disconnect post-funding, and same on the law firm side? What are the main issues that you run into with the funders once you start actually working with them?
Very briefly, I think reporting requirements need to be very, very clear in the facilities. In litigation funding, I'd say the funder can be very hands-on, but can also be quite hands-off, because we are taking the risk of an asset. But here we need to understand that the firm is really operating as it was when we diligenced it. And so one thing that everybody needs to agree on is who's responsible for collecting what data on what periodicity. Because for us, unlike litigation finance, where you can tolerate a loss rate, that's just part of what we do. Sometimes you win, sometimes you lose. In law firm lending, it's a zero default strategy. So we need to be able to anticipate any risk. It's never in our interest to enforce on a regulated business. It's just, imagine the headache. You guys live in that environment every day. We're regulated by financial regulators, but when we speak to lawyer and legal regulators, it's another level. So that's never the scenario we want. We're performing credit investors, so we want to get as much anticipation as possible from the reporting to identify something that's off.
I think it's about making it not a headache. In a way, we've tried to separate our finance and case rate systems so that they match what the funders want. So the way we do, the way we record the WIP, the way we do our invoicing, the way we chase our returns matches what goes to the funder. So as you run your business, it matches the funder. So you just need to find a funder that can work with the way that you do run your accounts and get the information from the lawyers as the case progresses.
I mean, yeah, absolutely. The way you track billable hours of your lawyers, for example, I mean, we're not going to ask you to reformat that. Typically we have sessions where we get demos from lawyers or the ops team at the law firms that show their system, what comes out of it. It's not like there's a standard for litigation finance portfolios, facilities, or law firm loans, so that's why you have to be quite flexible. But again, the model of the old partnership with no reporting and just basically practicing for the beauty of law, that's not the reality of especially not in the UK market for sure, and in certain European markets, the US market, I mean, you definitely get way more metric-driven reporting already there. If it's not there, I think we won't get to a closure on the transaction because of the headache factor, and I think everybody will lose their time. So that's why our hit rate on law firm loans is very, very low. I mean, from an inbound request or an opportunity resource to the closing, I mean, it really, on an annual basis, I can count the number of deals we do on my two hands, whereas the pipeline is huge, just because we stop conversations sometimes after one call. So it's very different. When something goes wrong on a loan, it gets very real. When something goes wrong on a non-recourse trade, like on a GLO funding or something, the funder took its risk. He's never gonna sort of try to chase you for money or try to. Anyways, so it's important that the fit works from the beginning.
Yeah.
Yeah, I try to take a pragmatic approach to this. I was a lawyer before joining Gramercy, and in my private practice, I had a funded practice. Omni, I think some people here, they funded me in my former life, and so I remember talking to them when we were doing our deal about reporting, and I take that to heart now when I'm on the other side, right? I think Hugo nailed it, which is there has to be flexibility because no two firms report, whether it's WIP or cost, whatever it is, the same way. And that's okay. We don't have just one set, you have to report it this way. And again, this is what we do up front. We work with the firm, what does your reporting look like? And how do we take the way you report and turn that into something we can use. We're not trying to create work for the firm, and the firm isn't trying to create work for us. We're just trying to mirror what we need to how they report. And often, again, if you're going to get a deal across the finish line, you have to see the world the same way at the end. And so we often have those conversations early on, because it will be a deal breaker. We're often looking at bigger deals, and being able to trust the reporting is critical. Because you can't get into a very large facility and then have questions about reporting, right? The accuracy of it. So we really do try to put that up front.
But one thing actually, and it's not just true to law firm lending, it's true to any credit transaction really, is you also got to choose your lender. Because you'll have institutions, like certain banking institutions or funds that are very rigid, and they have people all along the value chain that are paid to basically check very tiny things, and they'll be on your back every day. And if you're a firm that likes that, it's good. And certain firms are more flexible, and they're a bit maybe smaller organizations or big organization, but with a different setup. So you also got one thing we're very surprised. We're very rarely asked information about who we are. What's sufficient to law firms often is a term sheet. Josh will know, but in private equity, for example, or in private debt, you have management meetings where it's like a reverse diligence on basically it's like a beauty contest of sponsors basically coming in, meeting management, and then only you get invited to diligence. We rarely get that in law firm lending. So I think there needs to be a culture, obviously, of now that such conferences attract that many people from different horizons, there's also like an opportunity to pick the right fit. So I think you were saying this, we're not for everybody.
Yeah.
I guess we're also not for everybody. We're, for example, we're based in Zurich, so if you want to walk over to our offices, it's tougher if you're based in London or Manchester or wherever, and that may not be for everybody. You're time zone, quite a few time zones away, so that's also part of the discussion. And sometimes it's also cultural fit. I mean, there's so many factors, to be fair.
I mean, one thing that funding has done, I suppose, for lawyers, at least in the collective actions area, is that lawyers have to think about numbers because you're not getting paid as you go, and you have to do the reporting. So I think that's a big change from the non-funded era, and it's instilled some sort of discipline around how you look at a case from the beginning, at least in my experience.
I think it's a very good point. Yes, we see a lot of those claims that come to us that are very good claims, but they don't work on numbers. And yes, I think that's a new sort of development. And Chris, in the sort of last 5-7 years, do you think the ask of funders has developed in any way? Has it become more extensive, or the funding relationship?
I think there's a better understanding of the type of cases. So the cases that could be fundable, or the firms that could be fundable, and now there's a better opportunity for finance there. I think one of the areas that law firm financing should help is that the international work we do at Leigh has been less funders are less wanting to have a look at it because it's quite risky. But if it's in a portfolio of your firm funding against UK actions, employment claims, consumer claims, it's just part of the work of a firm. I think that is the opportunity to fund a broader basket of cases.
Thank you. Well, I think we have 1 minute left. Are there any questions from the floor? I think no, right, I can't see one. Okay, well, thank you very much, and join me please in thanking...
there
was a question. Sorry, we are blinded by the lights. So.
Hi, it's Anna Carolina from August Goodhead. It's a comment and then a question. I'm a witness of how a law firm can go stronger in partnership with their funders, from the due diligence process through the negotiation and then after the post-deal management. If you have a good communication, you can improve your processes, your governance, and this is definitely for the good. There is institutionalization and better governance practice. That said, it's really important as well as you also mentioned that we keep our regulatory standards high, that we don't compromise on that because of any some kind of type of reports that would be better for the funder or anything like that. And there is, of course, an importance to think about the staffing, but there is also the limit to not have any interference. My questions go more to the law firms. How do you make sure that you are at the same time working cooperatively with your investor, but not compromising on your duty to follow regulation and be independent?
What we've tried to do at Leigh is have a kind of an assessment committee that looks at the funding arrangements that come in to try and work out where there's commonality of terms with arrangements that we've got with our bank or with other funders, and try and separate out the lawyers so that the managers of the firm are looking up to the funders and down to the lawyers, but the lawyers can keep a level of independence, so there is very little interference, if any, between the funder and the clients. The clients are aware there'll be the funding in place, but it doesn't impact the decisions that are taken on their case. Just enables the lawyers to do more of the work they want to do. So it's having a kind of layer of management in between, which sounds strange in a bit of an antithesis to lawyers, but there is an acceptance. You need that layer of management to have some distance between the claimant, the lawyer, and then the funder.
So we are not funded as a law firm, but in the past I've had to deal with similar issues with shareholders, for example, where the firm is funded by shareholders, and there's always a risk of interference. And the only way you can deal with this, I mean, the way we dealt with it, was to just remind the shareholders or the investor that we have regulatory standards, and do you want to make some money or do you want to lose all of it? Is really the question.
I'm going to use that, by the way. That's good.
It's a very good question. We do see that a lot when we represent law firms, so borrowers and funding. It's educating investors, especially maybe foreign investors, about the way SRA rules work and restrictions they impose, and the requirements to privilege, etc. So that's a very good point. Thank you. Any other questions? Yes.
Just a very quick one. You mentioned that you're investing in senior lawyers, first and foremost, but thanks. You mentioned that you are often investing in senior lawyers, first and foremost, but you're not chaining them to their desks. So how do you prepare for kind of lateral hire risk? You've got a senior lawyer who just leaves.
Yeah, it's a great question. Part of the underwriting when you're looking at a firm is what is the retention, right? And we were talking earlier because you've been 17 years, and I asked how many lawyers have been at your firm for more than 20, and I was shocked when you said quite a lot. So there is a culture at firms, and you can. It's not science, it's a little art, but you can touch it, you can feel it, you can understand it. It's not a guarantee, but that's part of what we're trying to understand. When we look at hours, we're trying to make sure there is a balance. If you're working people too hard, that risk gets greater. So what is the mitigants the law firm can do, whether it's benefit package, whether it's shadow equity, synthetic equity, looking at their track record and talking to senior management. How are you staffing? How are you handling cases so that you can to the extent you can control it, so you can keep people, and then assuming you're not going to have 100% retention, what is the plan, right? If these lawyers leave, what do you expect? Because lateral hiring, it's kind of a crapshoot, right? And we've all done it. I managed a firm, and I did it, and the success rate's not always great. So what is the plan if people do leave, like internal and external? And then what is your integration process when you're hiring? Because that's going to have a large impact on success of the new lawyers. How does that integration work? What's the process? So we think a lot about it, but you can't control it.
I think the funding should make the lawyer's job better, though, because there's security for the work they want to do. You shouldn't be saying, well, now we've got funding, you've got to do 20% more work. It's just you can do what you wanted to do without worrying if one case falls down or two cases fall down because the firm has got the financial backing it needs. So the feeling at Leigh is it gives the lawyer security to do the law.
But also, back to, I'm being very redundant with my covenant point, but we have key man clauses in loans when we identify key man risk. That's part of the commercial diligence we do, is to identify sort of the leaders of the firm at various levels, the departments that are creating the attractivity for new hires and stuff. So we do have key man clauses, and it's not like, that guy leaves or the loan's in default. It's often there's a period, a standstill period, where that can be cured by finding suitable replacement and whatnot. Obviously, it's not our job to say who's the right person to hire in the end, but it should be a reasonable agreement with the law firm and the lender to have certain clauses like this. Or it could be like if you identify a very hot law firm, for example, in the field, and you think that they're going to get their associates poached or whatever, you could also have a covenant around retention rate. We at our firm, for example, we've got objectives around that in our balance scorecard, so why not in the loan? We're an asset-light business as well as an investment manager, so it's the people who also drive the deal flow and the analysis. So we have this in our corporate structure, so we can put it in loans for, again, professional services businesses.
The covenant is the starting point. I was assuming, that's your starting point. If it's a named partner and he's critical to the firm, there's got to be a guarantee that person's staying or a suitable replacement. But 100% right. You can't. That's number one on the list for sure.
Thank you. This was very informative. Thank you very much.